Welcome to EUPrivacyForAll Session43 on GDPR, Article 51, Supervisory Authority. Article 46 was finally renumbered Article 51. Article 51 sets what the supervisory authority should be in each member state. First of all, each member state shall provide for one or more independent public authorities to be responsible for the monitoring of the application of the GDPR, in order to protect the fundamental rights and freedoms of natural persons and to facilitate the free flow of personal data within EU. Each supervisory authority shall contribute to the consistent application of the regulation and shall cooperate with each other and the Commission. Where more than one supervisory authority is established in a member state, such member state shall designate the one that will be representing those authorities in the European Data Protection Board at EU level. Each member state shall notify to the Commission the provisions of its law which it adopts pursuant to this obligation, and without delay, any subsequent amendment affecting such an obligation. Key provisions in the GDPR that will be further detailed in dedicated sessions refer to the fact that the establishment of supervisory authorities in member states means that they are empowered to perform their tasks and exercise their powers with complete independence. But also, among more than 300 references to the part to be played by supervisory authorities nationally, there is in Recital 36 the mention that in cases involving both the controller and the processor, the competent lead supervisory authority should remain the one of the member state where the controller has its main establishment, knowing that the supervisory authority of the processor should be considered as a supervisory authority concerned, and that it should participate to the cooperation procedure. In Recital 80, reference is made to the representatives that should act on behalf of the controller or processor and may be addressed by any supervisory authority. Or Recital 84 and 94, mentioning that where a data protection impact assessment indicates that processing operations involve a high risk which the controller cannot mitigate by appropriate measures, it entails that a consultation of the supervisory authority should take place. In a quite long set of provisions laid down in Article 28, the Directive 95/46 reminded that one or more public authorities could exist in each member state. They will have to act with complete independence and being consulted when drawing up administrative measures or regulation is envisaged in a member state relating to data processing, and additionally that each authority shall be endowed with investigative powers, effective powers of intervention, the power to engage in legal proceedings. Each supervisory authority here claims, and the person concerned shall be informed of the outcome of the claim. Moreover, each supervisory authority was presented as drawing up a report on its activities at regular intervals, this report being made public. Finally, each supervisory authority was to be competent, whatever the national law applicable to the processing in question, to exercise on the territory of its own member states the powers conferred by the Directive. The obligation to cooperate was already laid down, and professional secrecy referred to. What should accountable data controllers and processors get prepared for? Controllers and processors should first identify and exchange with the one or several independent public authorities monitoring the application of the GDPR. They should pay attention to the set of regulation documentations released by these authorities and their EU counterparts, but also the European Union Court of Justice, the CEDH, and national courts in order to protect the fundamental rights and freedoms of EU citizens regarding the processing of their personal data. They should bear in mind that these national authorities will cooperate with each other nationally but also at EU level and will cooperate with EU Commission. They should specifically identify their lead supervisory authority, notably in charge of coordinating with the European Data Protection Board. And if the company or body concerned is acting both as a controller and a processor, it should consider that the supervisory authority in charge will be the lead supervisory authority of the controllers, where it has its main establishment, and that the lead supervisory authority of the processor, if different, will be a concerned supervisory authority. That is to say, it will participate to the cooperation procedure. So the question triggered now is knowing how will the set of cooperation mechanisms laid down in the GDPR with regard to supervisory and concerned authorities concretely work.